You're watching the presentation, Case Brief, DC versus Heller. I am Stephen Xiao. This presentation is prepared for the Business Law Class 2013 Calmat Spring, instructed by Professor Samuel Tang. Dick Heller, a resident in District of Columbia, applied to register a handgun to be used in his home, based on District of Columbia Firearm Control Regulation Act of 1975. DC banned residents from owning handgun and prohibit possession of unregistered firearms. District refused Heller's application. Heller alleges this refusal to registration handgun against Second Amendment of the United States Constitution, as well as against firearm carrying license or trigger lock requirement at home. Heller went ahead and filed the case. The final judgment was entered in June 2008. Heller filed this lawsuit in the Federal District Court for the District of Columbia on Second Amendment grounds. The District Court dismissed Heller's complaint. The Court of Appeals for the District of Columbia Circuit reversed and directed the District Court to enter summary judgment. Provision of the Firearm Control Regulation Act of 1975 was unconstitutional. The Supreme Court affirmed the Court of Appeals for the District of Columbia Circuit in Heller versus District of Columbia. Issue: what does Second Amendment protect? Holding: the text of Second Amendment, a well-regulated militia, being necessary to the security of a free state. The right of a people to keep and bear arms shall not be infringed. Rationale: a well-regulated militia being necessary to security of a free state indicates a purpose which does not limit or expand the scope. The right of a people to keep and bear arms shall not be infringed, imply an individual right to keep and bear arms. Interpretation of the Second Amendment by scholar courts and legislations from ratifications through the late 19th century also supports court interpretations. The Second Amendment right is not the right to keep and carry any weapon or any measures for any purposes. Disposition: the court decided in favor of plaintiff's final disposition of the case. District of Columbia Regulations Act was an unconstitutional banning. Court decided struck down the requirement of a firearm be kept trigger lock and struck down the restriction of residents from owning handguns except registered before 1975. Opinion: my opinion is concurring. Since the handgun ban and the trigger lock requirement even applied to the self-defense, it has violated the Second Amendment. Since any legislature's authority regulate private civilian uses of a firearm actually infringed the right to keep and bear the arms of the people, and legislatures regulate the non-military use and ownership of the weapons limited the right to keep and bear the arms of the people. Instead, I would say the regulation should, for lawful purpose, indicated this is for the self-defense and to prevent concealed weapon or the possession by felons or the mentally ill people, and try to forbid carrying the sensitive places such as the schools or government buildings, and to set up laws, conditions, and qualifications on commercial sales of the firearms. Government should be the institution to service the people, not to regulate the people. And the government should follow the Constitution, not to against the Constitution. If ban the guns, then only criminals will have guns. Guns don't kill people, people kills people. So about mental health, not the guns. The any control of at all is a slippery slope to full gun bans. Thank you.